Hello, everyone. This is Tom Fox back again with Matt Kelly for another episode of the award-winning Compliance Into the Weeds. Welcome back, Matt.
Hello, Tom. Good to be here.
After a short hiatus for the week of our country's birthday, we're back with some pretty weighty stuff. And we're going to take a look at some of the term-ending Supreme Court cases, but from a compliance professional's perspective, as opposed to lots of other perspectives we could go into. So, Matt, which case do you want to start with?
Oh, Tom, there are numerous ones to pick. I think the three that compliance officers probably have thought about are the Jarkesy decision, which ruled that the SEC cannot use in-house tribunals for enforcement proceedings. There is the Loper case, which overturned the Chevron doctrine after 40 years about how agencies can adopt new rules. And then there is the Snyder decision, which narrowed the scope of federal anti-corruption law for bribes paid to state and local officials in the United States. All three, I am sure, compliance officers have heard of in the headlines. Although, Tom, my contention would be all three really don't matter that much to corporate compliance officers, which is probably the big takeaway you would have as you're talking to other people in your enterprise who also have heard about these things and are probably wondering, what does this mean for our company, for corporate legal issues, for corporate compliance programs? So we could take either. I think the big ones are the Snyder ruling about corruption or the Loper ruling narrowing the Chevron defense or Chevron deference. I'm happy to take whichever one you think is more interesting.
Could we just say a couple of words about why we both think Jarkesy will have literally no impact on the compliance professional? And Matt, from my perspective, it is that if the SEC is going to bring a charge under the FCPA, they have to bring it in. I think they have to bring it in U.S. District Court because it's going to be a criminal charge as opposed to a civil case. And they have not brought an in-house FCPA case in at least 10 years. I was trying to think about that, but do you have another take on why Jarkesy, we both agree, is the least important for compliance professionals?
I mean, the short answer is what the Jarkesy ruling actually said was that an individual has the right to take this accusation against them to federal court and have your case against you heard in court, not in front of a administrative in-house judge that the SEC does have. So the short answer is this is really potentially useful for individual defendants. However, you corporate compliance officers are not worried about individual defendants. Corporate cases get heard in court. And if your company wants to drag things out and says, we're going to take it to federal court, for most corporate misconduct cases, the SEC be like, yeah, sure, we're happy to do that. And by the way, your legal bills are still going to go up, which they are. I mean, the vast majority of SEC complaints against companies are settled. They're never going to see the inside of any court other than just to rubber stamp it. And you're right, Tom, I don't even think in front of, say, accounting fraud or any other SEC jurisdictions, I can't think of a corporate case that has been educated in front of an in-house administrative SEC judge in years and years. Potentially, there may be some issues that in other regulatory agencies, they don't have the statutory authority to take somebody to federal court. So if you are in an OSHA compliance matter, they're supposed to go to in-house OSHA judges, and this ruling also applies to them. So what is OSHA supposed to do for enforcement if it's not allowed to take a case to administrative judges? And by law, it can't go into federal district court. Like, how's that supposed to work? I don't know. I don't think the Supreme Court really thought that through. I don't think a lot of lawyers have good answers. I do know that most of our listeners are primarily concerned with accounting fraud, insider trading, FCPA enforcement. Jarkesy doesn't really affect you and your corporate woes in any of those issues.
Let's move on to Loper, Matt, because the Chevron deference defense said essentially that if there is a rulemaking made by an agency pursuant to a new U.S. law, the court should give deference to the agency's decision on the rulemaking as long as it wasn't arbitrary and capricious. And now we've got something else But once again, in the FCPA arena, the SEC has no formal rules around the FCPA. It's a little bit different in the Department of Justice, but it's not clear to me that the Chevron or Loper would apply to something like the evaluation of corporate compliance programs or the FCPA Resource Guide, first or second edition.
Yeah, that's exactly right. And in fact, I will say that over the weekend, I received a text message from a general counsel I know, somebody who I respect, and he is the general counsel of a mid-sized manufacturing business. He has previously run ethics and compliance programs at large publicly traded manufacturing businesses. And he said, "Oh man, this is terrible. This ruling. Think of all of the Justice Department guidelines. They're all going to go out the window." Now, I like this general counsel, and I generally think he's a bright person. I did wonder what planet he was on when he told me that, because the Justice Department's guidelines for an effective compliance program and the U.S. sentencing guidelines, 7 elements of an effective compliance program, they are outside the scope of anything that has to do with Chevron. They are guidelines. They are not rules. They cannot be challenged in court, and nobody actually has to follow them. In theory, the Justice Department could throw all its guidelines out, and when it's adjudicating your case of what's FCPA or anything else, and they could make up some other rule. They could, or not a rule even. We have to be precise in our language. They could take some other approach. These guidelines around what an effective compliance program should be are only guidelines. They can be dispensed with. They can be updated, which the Justice Department does on a regular basis. In the sentencing guidelines, a judge does not actually have to follow them. And again, think it through. For a judge to discard the sentencing guidelines and looking at your compliance program, that implies that it went to trial, that there was a verdict, and the judge is having a sentence that he or she is going to mete out against your company for its corporate misconduct. That never happens here in the real world. Companies never actually fight this to the death. They are going to settle, and when they settle, that means they're going to go to the Justice Department and say, "What can we do here?" And the Justice Department is going to fuss over its guidelines and maybe interpret them one way or another way. And maybe the Trump administration did it one way. Biden will do it another way. All of this has nothing to do with agency rules. Tom, I will say that, my general counsel friend also did raise a valid point that future rules are going to be more fraught for an agency to adopt, because it will be easier for some right-wing group somewhere to challenge those new rules in court. So again, think this through. If regulations in the future might be more subject to litigation risk, agencies are going to be more hesitant or thoughtful about adopting new rules. That means the agencies are going to default to enforcing the rules they have more vigorously. So we're back to regulation by enforcement, and probably propped up by all of these other, I guess I'll call them administrative ephemera of speeches or guidance notes or settlement orders that, Tom, how many settlement orders have you and I parsed every single word over the last 10 years trying to figure out what exactly does this mean and how would it be applicable to other companies? And none of that is the same as an agency adopting a rule which people could then read and then point at and say, okay, that means I should do this. If the rulemaking becomes more uncertain, more hesitant, more subject to legal scrutiny, we're just going to have more regulation by enforcement and this dark matter regulation, which frankly, I thought conservatives were opposed to that. And therefore, why would they want to bring about this change of circumstance, which probably is going to cause more of it instead of less of it? But we're going to have regulation by enforcement. And again, then you're back to, once the enforcement people show up, what guides them is the guidelines on what an effective compliance program is, what the sentencing guidelines say, how is the legal team going to settle this? And we're right back to the compliance team being in the thick of it and what an effective compliance program is going to matter. So it's not just that Chevron doesn't touch on, or the Loper case ending Chevron. It's not that the Loper case is even just irrelevant to what you worry about. It's going to make what makes compliance hard. It's going to make that more common, which is regulation by enforcement and by speech. And look, I love a good speech, so I'm okay with it. But I do think that in the fullness of time, courts and Congress will come to regret ever thinking the Loper ruling was a good idea.
The FCPA Resource Guide is a direct result of the 1998 amendments to the Foreign Corrupt Practices Act itself, where the U.S. agreed to the OECD requirement for formal written guidance. So that's a part of that law to start with. And I also thought about things such as when Rod Rosenstein announced the moving from the pilot program to the FCPA enforcement program, which instituted the discounts that a company could receive if they self-disclosed, if they remediated, if they cooperated, and they engaged in profit disgorgement, and they didn't receive a full declination. So my hope is that the Department of Justice can continue to do those sorts of things around their own prosecution as well. Let's perhaps move over to the last one, which could be, I think, deliciously juicy, and that's Snyder. You want to maybe go into why we both think it was just an inane, fraud-based decision by the court, or just waive that and go into what the compliance professionals should draw from this?
Oh, no, this was inane, and we should explore the inanity of it and hold it up to full view, because this was just, you got to wonder what planet the conservative majority was on when they came up with this idea. So the case involved Mr. Snyder, who was the former mayor of Portage, Indiana. And in 2013, he basically engineered a contract for garbage trucks in his city so that only one company, the Great Lakes, I forget the name of the trucking company, but Great Lakes something or other, Peterbilt. Great Lakes Peterbilt were the only bidders who would be able to meet the terms of the contract. And so they won the contract for the 5 garbage trucks. And then lo and behold, the next year, they gave the mayor, Mr. Snyder, they gave him a consulting contract worth $13,000. Never mind that there was no actual written contract, that he performed no services, and that when the feds ultimately brought a bribery case against Mr. Snyder for this, witnesses testified that this was a no-show job in exchange for him setting up Great Lakes Peterbilt to win this contract. So this was clearly some sort of corrupt bargain where the consulting gig was a reward for fixing the contract so that Great Lakes Peterbilt could win it. That's what it was, and we all can see that. However, the court said that because the payment and the contract arrived after Mr. Snyder issued the contract, it was actually a gratuity, akin to when you give a $25 Amazon gift card to your kid's teacher at the end of the school year for a job well done, or for giving your local state rep a school sweater when he or she turns out to give a speech at the pep rally. This was like that, they said, and therefore it was not a bribe. Now, I should say that the minority, this was a 6-3 decision, and we can all guess that this was a liberal-conservative split, because how else would it go? The minority said, what I basically said is like, what planet are you people on? Very clearly, this was meant to reward Mr. Snyder for his corrupt act of fixing a contract. But the majority said, no, it's a gratuity, and therefore, under federal anti-corruption law, it is not a crime. This only applies to, I believe it's section 666, which seems like an apropos number here, of the U.S. Criminal Code, which talks about improper bribes and gratuities for federal, state, and local officials. And basically now this has invalidated the gratuity approach for state and local officials. I guess you can give them all sorts of gratuities after the fact to reward them for things they normally would be doing anyway, such as issuing a contract. That's where it is. Tom, if you want to light this decision up, please do, because I think it's preposterous. But those are the facts that brought us here.
I would just point out that 2 of the justices have been accused of taking gratuities for services rendered, and now they have now made that legal. So seems to me it'd be a bit of a conflict of interest to me. But the juicily delicious part, Matt, is now somebody gets to try to apply this to the FCPA. I don't think they can do it on the statute's face, but even if you can convince me, or hypothetically we want to say it's possible, how would you think through that in the corporate world? Is it just a matter of bright line timing after contract awarded or as opposed to before or something else?
I think this idea, this fantasy that I guess maybe pro-corruption, I was about to say anti-corruption people, pro-corruption people have, this is a pipe dream. This is not going to happen. Let me knock through, I think I had 5 points I sketched out about why this is unlikely to ever take root. Number one, this assuming somebody somewhere does say that actually now, if you use that ruling and apply it to the FCPA, it means a gratuity given to a foreign official for something they would normally do is not a crime. So I could just restructure all my bribes to be gratuities, and now I'm FCPA risk-free. That is a harebrained idea, but at the least, it's going to take years to resolve, and it may not go the company's way. So your compliance program of today still will need to continue its FCPA policies and procedures for the foreseeable future and probably forever. Number two, let's say you actually get away with this harebrained idea. It could still be a bribe in the foreign country, even though you have now structured it as a gratuity and it's not an FCPA violation. If it's still a violation in some other country, I'm not sure your situation has improved all that much. Third, Tom, and maybe I'm naive for talking about it this way. How would the gratuity approach actually work in practice? Because what corrupt official is actually going to agree to take this gratuity arrangement without any assurance? Because you can't put that sort of a thing in writing. But, if you do put it in writing that, yes, if you decide it this way, we absolutely will give a gratuity to you or your brother-in-law or whatever. That to me suggests that it's corrupt intent. So we're right back to where you started. Fourth point I have, and I've got only the 2 more now, is prosecutors already focus on finding corrupt intent in an FCPA violation. So that is going to become even more important now, because if you can document the corrupt intent, then you do have a case that can be brought. So prosecutors are going to lean even more on corporate legal and investigation and compliance teams, and they're going to get even more in your hair and in your face about the internal investigations you've conducted to make sure that you turned over every stone, you searched every email and every secret database and every Gmail address all the employees have. You searched it all to make sure there's no corrupt intent anywhere. And even if all of that somehow gets overcome, the other thing is that wouldn't you still have a books and records violation from the SEC? Because if there's no criminal offense, the SEC can still bring an enforcement action, and they've done it all the time. And, let's go back to Mr. Snyder, the mayor of Portage, Indiana, and the no-show job he had. Great Lakes Peterbilt was a privately held business, so there wasn't any FCPA violation there. But for a publicly traded company, it would have been a books and records violation. They said, he's a consultant. Okay, where's your contract? We don't have any. Where's the documentation of what you actually did? We don't have any. Where's any proof that what you paid him was commensurate for what services he was actually giving you in the great market of Portage, Indiana? We don't have any. You're going to have that if you want to avoid the FCPA violation, even if the gratuity thing somehow makes the criminal case go away, which I'm still, as I said before, I'm not convinced that's going to happen either. So this is a screwy case just on the face of it. And then as you pull on these threads, you just have to wonder, come on, folks. This is not going to result in the FCPA risk vanishing like a fart in the wind. It's just not going to happen.
So let me pick up on that last one, because tried to think through how a company would structure its internal controls and books and records to show a payment made after a contract was awarded with a sufficient distance, and that payment or other, whatever other might be, was a gratuity. Would you have a new bookkeeping entry, gratuities paid? Or would you have, because you have to properly describe the payment, would you have something else? And how would you know it was a gratuity without the evidence of the gratuity? And what evidence would that be? Somebody did something for us. So I really just think this, as you pointed out, is a complete exercise and perhaps a lot of fun. I think will have no practical impact in the real world going forward. And frankly, I cannot imagine any of our colleagues who sit across the table from the Department of Justice even considering making this type of argument. to the DOJ without losing all credibility.
Well, Tom, and I should point out a couple of other, small facts people have to remember is that if you are in healthcare, you're subject to the anti-bribery and corruption provisions of the anti-kickback statute. So everything we just said has nothing to do with anti-kickback. Your risks for that were still here before. They are still what they are today, and they will be that in the future. So your anti-corruption compliance program in healthcare, that's going to keep rocking and rolling as always. Second, Tom, you had mentioned that at least two of the justices have questions about improper gratuities they have accepted, and maybe there's conflict of interest. Fun fact, the federal law for anti-bribery and gratuities, this decision only invalidates that as applied to state and local officials. The federal officials are still subject to the same sort of anti-corruption, anti-gratuity, whatever you want to call it here. But the law actually does apply to the federal officials, which would include Supreme Court justices. And I do actually believe that Justice Clarence Thomas, clearly, at least, he has got some sort of gross conflict of interest if he's not outright corrupt. And I'm not a big fan of what Sam Alito has been doing either. And maybe there are other court justices you're thinking of too, because it seems like quite a few of them have these conflicts. But everything we're talking about only applies to state and local officials getting improper gratuities. Federal officials, like them, they can't get improper gratuities right now. So it's very narrowly defined. We're only talking about federal enforcement against state and local officials. So if you are paying these bribes to state and local officials under the guise of a gratuity, you might well be violating state law, in which case the state attorney general is now calling you on line 2. And just because you got DOJ off the phone on line 1, I don't think, again, your situation has improved. I don't want to say this isn't a big deal because it's an affront to common sense. But in the practical application of anti-bribery law, compliance officers and corporate legal teams still have a lot of risk to worry about and a lot of compliance burdens to meet. And none of that has changed because of this or either of the other two decisions we mentioned and discussed earlier.
Have you been getting any inquiries or hearing or sensing any traffic from compliance officers with questions about this case, Matt?
I have had a few people speculate about it, but more like kind of sneering at the court's terrible logic here. And in fact, I can even remember I was reading, I think it was a law bulletin from Baker McKenzie analyzing the Snyder decision, where it said that clearly it seemed like the majority and the minority on the court, they were talking about two different cases, even though they weren't, where the majority just fell in love with its own theory about what a gratuity is or isn't and what public officials do or don't do and what is a corrupt versus an unofficial act or whatever. But, the minority were just pointing out the facts of the case, which is that this was given to the mayor, Mr. Snyder, as a reward for deciding to fix a contract so only one company could win it. That was corrupt. And everything, and the statute does say that if you're acting in corrupt intent to influence or be rewarded, come on, what is a gratuity but a reward? To behave in a certain way. So, a lot of compliance officers who I do see talking about this are more saying, what on earth was the Supreme Court majority thinking that this is the right rule? Of course it is not. Of course, Mr. Snyder was up to his eyeballs in corrupt intent. That seems patently clear. And just because the court wants to fall in love with its own theory about official acts and corruption and gratuities, what does that have to do with reality? Not much. It's shameful. I do hear some people thinking that, this might make some employees more tempted to try to offer gratuities. But, if we're just calling a gratuity to cover up the fact that it's really still a bribe or a corrupt payment or a reward for acting corruptly, compliance programs are supposed to focus on the ethical issue, which is that corruption is bad and improper payments are bad. What law applies to that may differ, and how the payment might be structured can change. But the moral point here that you want to keep in mind if you're a compliance person, the one that you're communicating to employees, is don't engage in corruption. And I think most people know it when they see it. It's just they're disappointed the Supreme Court made this ridiculous ruling.
Hope our listeners, Matt, will understand that at least we don't think these cases had literally any impact on our profession or the compliance profession going forward.
Thank you, Tom.